Steve Palmer here, Lawyer Talk Podcast. You can check us out at lawyertalkpodcast.com. Today, another riveting episode of DUI 360, where we cover all things DUI. Here in Ohio, we call it OVI. And I bring that up because today I'm going to talk specifically about Ohio and why some would say Ohio sucks for OVI Defense. And maybe OVI Defense sucks everywhere, but Ohio's got a particular problem I'm going to try to describe today and break it down. See, Ohio, most states have two ways you get charged with OVI or DUI. One is the old-fashioned way where you're just driving under the influence of alcohol. That's what your granddad would have known about. He would have been pulled over because he's swerving within his lanes, gets out of the car. Maybe think Steve Martin and the man with two brains, can't do field sobriety tests, whatever. He's too drunk to drive, and they have to prove that he's too drunk to drive. And that means he's driving under the influence of alcohol. That's DUI. Now, the other way is called a per se way. In Ohio, we call it a per se offense, meaning it's a crime if you're behind the wheel and you have a prohibited blood alcohol content as measured by your blood, breath, or urine. And there's others too, like drugs of abuse, including marijuana. That's a different topic. But that's a per se offense. In other words, it doesn't matter. You could be driving completely sober. You could look completely sober. You could act completely sober. There's those people, I've known them, who can just drink a whole bunch of booze and not look like it. This is designed to impact, or this is directed towards those folks. Now, why does Ohio suck? Here's why. Because in Ohio, we have a rule based on a case that happened back in, I think, 1984 called State versus Vega, VEGA. I'm going to geek out for a second, bear with me. But State versus Vega says that in Ohio, we're not allowed to go into a courtroom and attack the general reliability of a breath test machine. What does that mean? I can't stand in front of a jury in a per se OVI offense and say, folks, you know what? Your computer sometimes malfunctions. Anybody who's had headphones on and been around a power influx, or if you're near a outlet or something like that, you hear the hum, you hear the buzz. It's called radio frequency interference. Or maybe if there's all sorts of other ways to scientifically break down why breath test machines are not, or we'll just say subject to inaccuracies. One would be something called a conversion ratio, how you convert alcohol and how fast you do it, and what the I'm not going to go deep into the science, but it's called Henry's Law. The breath test machines make certain assumptions about that. But I'm not allowed to stand in front of a jury and say, folks, this machine is not always accurate. Generally speaking, it can make mistakes. And here it may have made a mistake. Now, what I am allowed to do is say, in this particular case, there's a specific mistake that applies to my specific client. But I'm not allowed to attack the general reliability machine. And Ohio would say, well, that's because our esteemed director of health has already determined that machines are reliable. So this is why I'm bringing this up, because in today's day and age, there's this, I'm not going to get political, but there's this huge debate about our administrative body of government, where unelected administrative officials are making rules, and those rules apply to us, and we don't ever vote on them. Well, here we have a director of health who presumably, according to the Ohio Supreme Court, has said, you know what, you guys don't need to worry. I've looked at these machines and they're accurate. So you don't worry about it. It's not even worth your time, Mr. Defendant charged with OVI, to have your lawyer step into a courtroom and attack the machine, because I am saying it's reliable. Now, if you're thinking to yourself, that doesn't sound right, I agree. I don't think it sounds right at all. I've challenged this constitutionally all the way up and down. I've tried in federal courts. I've tried in state courts. I've tried my workarounds. We DUI lawyers in Ohio hate this. And from what I can tell, there's not many other states, if any, that actually have this similar type of rule. Hawaii, believe it or not, went through this way back when, before Vega, and Vega actually cites or talks about Hawaii. Anyway, it's a problem defending OVI cases in Ohio. And that's why in Ohio, when you take a breath test, you really made it more difficult to defend the case. Now, I'm not saying you should or shouldn't take a breath test. That's a different discussion for a different day. And as everybody knows, this isn't legal advice. This is just me discussing interesting topics if you find such topics interesting. So what does all this mean? It means that in Ohio, if we have a breath test, it's a harder row to hoe to defend it. Doesn't mean there are some things we can do. I mean, we can challenge whether the results should be admissible pre-trial by motions. We force the prosecutor to come in and say, well, at a minimum, you have to show that you followed the guidelines for administering the breath test. But it's not the same as standing in front of a jury and saying, you know what, how many people have had to reboot your computer in the last 30 days because it was malfunctioning, or your phone wasn't doing what it was supposed to do, or any other electronic gadget that you have. That's the same here. We can't rely on these beyond a reasonable doubt. You wouldn't in your own affairs, and you wouldn't here in this courtroom, and you shouldn't with my client. Don't get to make that argument in Ohio. and it sucks. Anyway, that's DUI 360, Lawyer Talk, podcast.com, off the record on the air. Till now.